The 9,934th meeting of the Security Council is called to order. The provisional agenda for this meeting is International Residual Mechanism for Criminal Tribunals. The agenda is adopted. In accordance with Rule 37 of the Council's Provisional Rules of Procedure, I invite the representatives of Bosnia and Herzegovina, Croatia, Rwanda, and Serbia to participate in this meeting. It is so decided. On behalf of the Council, I welcome His Excellency Mr. Nenad Vučić, Minister of Justice of Serbia. In accordance with Rule 39 of the Council's Provisional Rules of Procedure, I invite the following briefers to participate in this meeting. Judge Graciela Gatti Santana, President of the International Residual Mechanism for Criminal Tribunals, and Mr. Sergei Brammertz, Chief Prosecutor of the International Residual Mechanism for Criminal Tribunals. It is so decided. The Security Council will now begin its consideration of item 2 of the agenda. I now invite Judge Graciela Gatti Santana to speak.
Thank you very much, Madam President. Allow me to congratulate you on assuming, and your country for assuming the presidency of the Security Council. This morning, I am pleased to present the mechanism's 26th report on the progress of its work and to address for the first time the Council's newest members. For the mechanism, engagement with the Council and hearing your views on our ongoing work remain paramount to ensuring that we properly fulfill our mandate. Before updating the Council on our recent activity, I note that today's debate is 1 month from a moment of historical and moral significance, the 30th commemoration of the 1995 genocide in Srebrenica. In July 1995, up to 8,000 Bosnian Muslim men and boys were systematically executed, targeted solely for their identity. Approximately 30,000 women, children, and elderly persons were removed from the enclave by force. The very mention of Srebrenica evokes forced displacement, mass execution, and enduring grief, a grief carried by the survivors, including the mothers, wives, sisters, and daughters who continue to seek justice, truth, and remembrance. Through landmark rulings, the International Criminal Tribunal for the former Yugoslavia and subsequently the mechanism confirmed that genocide was perpetrated at Srebrenica. Likewise, the International Criminal Tribunal for Rwanda determined that the 1994 genocide against the Tutsi in Rwanda was a historical fact beyond reasonable dispute. With the Council's support, the mechanism and its predecessors have made clear that holding the highest political offices or military ranks does not shield perpetrators from accountability for the gravest crimes. Madam President, with the adoption of Resolution 1966 in 2010, this Council initiated a principled transition from the Rwandan and Yugoslav tribunals to a cost-effective and temporary structure that was no less committed to justice and accountability. The mechanism continues to embody this vision, executing its mandate with focus, fairness, and efficiency. To illustrate, last November, at the beginning of the reporting period, the mechanism's appeals chamber heard evidence and arguments, deliberated, and pronounced its judgment in the review proceedings initiated by Mr. Gerard Takirutimana, all within the course of 1 week. Although his request to reverse certain convictions was denied, the review procedure remains an essential guarantee in upholding due process rights, and the mechanism again proved that it could conduct such a complex matter with maximum efficiency. While all active core crime cases have concluded, the mechanism's continuous judicial activities proceeded apace. During the reporting period, the judges of the mechanism issued over 100 decisions and orders, nearly 90 of them pertaining to the mechanism's continuous judicial functions. 30 of those decisions and orders related to access to confidential information and requests for the variation of protective measures, demonstrating the mechanism's critical role in safeguarding witnesses while also contributing to national prosecution efforts to close the impunity gap. Turning to contempt of court, in February 2025, a single judge charged a defense counsel for violating judicial orders while representing Mr. Agustin Girabatoire in relation to potential review proceedings. Another single judge is currently considering whether the matter should be referred to national authorities. The threat of contempt for violating judicial orders remains essential to guaranteeing the integrity of proceedings and witness protection. For example, the current contempt matter is connected to a prior case involving a broad scheme of improper payments to witnesses and violations of judicial orders that were aimed at overturning Mr. Girabatoure's convictions. Nevertheless, the mechanism has narrowly exercised its contempt jurisdiction, and in line with the statute, the last two contempt cases have been referred to states. In the context of sentence enforcement, as you may know, Mr. Ratko Mladic has recently sought release on humanitarian grounds due to his health. I cannot say much as the matter is pending adjudication. However, I am mindful of the importance this Council has placed on ensuring that those detained under the authority of the mechanism are afforded care in accordance with international standards. I can assure you that those standards are fully met and that Mr. Mladic, who remains in the mechanism's detention unit in The Hague, receives high-level multidisciplinary care. Moreover, he is closely and frequently monitored, including by various medical specialists. Concerning the mechanism's judicial roster, one judge resigned in May following her conviction and sentencing in the United Kingdom. Once the mechanism learned of the pending criminal investigation, the Secretary General was promptly informed and he waived her immunity. During the pendency of the criminal proceedings, I also acted to protect the integrity and efficient functioning of the mechanism, including by discontinuing the judge's participation in the business of the mechanism. Madam President, the issue of state corporations remains pivotal not only to the mechanism's efforts to reduce costs and complete key functions, but to fulfilling the humanitarian principles upon which international criminal justice is founded. One example is the ongoing situation of Mr. Félicien Kabuga. Though his trial has been indefinitely stayed, he remains detained in the mechanism's detention unit in The Hague in the absence of a state for his provisional release. Notably, in April this year, an independent medical expert determined that Mr. Kabuga was generally not fit to fly, including to Rwanda, the one country willing to receive him to date. The trial chamber has already put additional questions to the expert and is awaiting responses before deciding what weight to give his report. However, Mr. Kabuga's continued detention implicates due process principles that the mechanism is bound to uphold. A solution cannot be found in the absence of a suitable state to which he can be safely transferred. The same detention unit also continues to house 3 convicted persons, Mr. Ratko Mladic, as I already mentioned, along with Mr. Jovica Stanisic and Mr. Miko Stanisic. While the mechanism remains profoundly grateful to its current enforcement states, we require additional states to enforce these sentences in order to reduce our operational footprint and eliminate the prolonged uncertainty for these convicts. As another example, the mechanism continues to seek resolution of the situation of 6 acquitted or released individuals who were relocated to Niger in December 2021. These individuals were denied rights and liberties that had been guaranteed through an agreement between Niger and the United Nations. The Registrar continues high-level engagement with the authorities in Niamey to facilitate the implementation of this agreement. And a single judge is also presently considering whether the relocated persons can safely return to Rwanda in the context of determining the mechanism's obligations to provide them with continued financial assistance. Fundamentally, support by member states is required to ensure a lasting rights-based solution. Finally, The contempt case against Mr. Jojic and Mrs. Radeta remains unresolved. Serbia continues to refuse to execute the outstanding arrest warrants for these accused, despite its legal obligations and the repeated referrals of the matter to this Council. Madam President, looking ahead, I wish to highlight key developments in our future planning. As you know, Resolution 2740 of 2024 tasked the Secretary General with providing by 31 December 2025 an updated report on the administrative and budgetary aspects of the options for possible locations of the archives. The resolution also asks the Secretary General to report on options for the transfer of the functions of supervision of sentence enforcement and assistance to national jurisdictions on prosecutions. The mechanism's leadership has worked across all organs and both branches to gather relevant information and produce thorough analysis on concrete options for the transfer of these functions to share with the Secretary General. While the assessment of the Secretary General is pending, allow me to briefly set out some of my own preliminary reflections, particularly regarding the potential transfer of the supervision of sentence enforcement function, which falls squarely within my remit as president of the mechanism. It may be feasible to transfer certain administrative aspects to states, such as the day-to-day supervision of conditions of imprisonment. By contrast, the adjudication of applications for pardon, commutation of sentence, or early release entails considerations of fundamental importance to the justice cycle that may be jeopardized if dispersed to various national jurisdictions. Transferring this activity would result in unequal treatment of the mechanism's more than 40 convicted persons, given the significant disparities in domestic regulations. In many cases, it could lead to release far earlier than any sentencing chamber may have anticipated if domestic release provisions designed for ordinary crimes were applied. Transfer to states would also eliminate the judicial consultation process, which benefits from the views of international judges who impose the original sentences or possess unique insight into the relevant cases. In my view, this specific activity should remain at the international level. When all fugitives are accounted for and court crime trials and appeals are completed, deciding whether convicted persons should be released is of central importance to the justice cycle. Undermining this decision-making process will undo decades of work that, until this point, has held impunity in check. Moreover, keeping this at the international level is a standard. Notably, the United Nations and Cambodia affirmed that the extraordinary chambers in the courts of Cambodia should continue its supervisory role in sentence enforcement. The Residual Special Court for Sierra Leone also continues to supervise the enforcement of sentences within its jurisdiction. Separately, I note that Resolution 2740 does not ask the Secretary General to report on possible options for the transfer of continuous judicial functions. Nevertheless, I consider it opportune to invite the Council to exercise patience and caution in consideration of this matter. The continuous judicial functions entrusted to the mechanism implicate fundamental rights, ensure witness protection, and remain essential to ensuring the integrity of international proceedings. Converting certain activities into non-judicial matters or transferring jurisdiction over them to states, for example, raises complex legal and practical questions requiring careful deliberation. This is not to say that workable, just, and fair solutions for transfer or even termination of judicial functions will not emerge, particularly given the expected decline in continuous judicial activity in the coming years. It is simply to highlight that while judicial work continues apace, it may be preferable to keep these functions at the international level while ensuring that sufficient due process protections exist and that the interests of justice are adequately protected before transfer or termination. For now, the mechanism will continue to fulfill its mandated responsibilities, and I, as President, remain committed to streamlining our work in line with the Council's vision. To this end, in May, I submitted to the Mechanisms Rules Committee proposed amendments to the Rules of Procedure and Evidence, which are aimed at limiting the prospect of resource-intensive proceedings, and in particular, in court hearings. Building on prior revisions to our sentence enforcement practice and following consultation with the registrar and the prosecutor, I also issued a revised practice direction to streamline the designation process and expand opportunities to engage with potential enforcement states to secure prisons for our convicted persons. Madam President, as we near the 30th commemoration of the Srebrenica genocide, we are reminded that justice is not a finite endeavor. It is a continuous commitment. The mechanism stands as a guardian of this commitment through preserving the legal truth established by the tribunals for the former Yugoslavia and Rwanda, ensuring accountability in line with due process, and affirming the dignity of victims and survivors. Our work honors the loss and resilience of those who endured unimaginable suffering and reflects the international community's resolve to confront impunity with principle and perseverance. In these times of global challenges and limited resources, we remain dedicated to fulfilling our mandate, but acknowledge that changes are necessary so that our remaining contributions to the justice cycle are delivered at a cost that the international community can support. Thus, we will partner with this Council as it seeks to preserve the legacy of the tribunals for Rwanda and the former Yugoslavia in a further reduced mechanism and ultimately beyond its operational lifespan. I am grateful for the opportunity to address you, and I look forward to hearing your views on our work. Thank you for your attention.
I thank Judge Gatti Santana for her briefing, and I now give the floor to Mr. Sergei Bramertz.
Madam President, Excellencies, good morning. Thank you for the opportunity to again brief you on my office's activities and results. Details about our work are in the written progress report. There are three issues I would like to highlight today from the past, the present, and the future. Madam President, Excellencies, my office arrested the last ICTR fugitives in recent years, Felicia Kabuga and Fulgence Kayishima. Although neither will be tried by the mechanism, both cases remain pending. 21 months after the trial chamber halted, the trial litigation continues regarding Kabuga's future. The outstanding question is still what will happen with him. At present, Kabuga remains in the mechanism's custody with his medical and personal care provided at the mechanism's expense. The defense has sought, so far unsuccessfully, for Kabuga to be permitted to reside in European countries. The prosecution has proposed that Kabuga be returned to Rwanda, his country of origin. The situation is not so dissimilar from that of the persons acquitted or released by the ICTR many years ago. They remain in Niger with uncertain status and still receive mechanism funding. My office believes, like normal practice in domestic jurisdictions, that Rwandan nationals should be returned to Rwanda after the proceedings are completed. But whatever the solution, these matters need to be brought to a conclusion. Turning to Kayishima, 2 years after his arrest, he remains in South Africa. In that time, a stalemate has developed. A mechanism judge decided that Kayishima should be transferred from South Africa to its custody in Arusha, Tanzania. He will then be transferred to Rwanda to stand trial pursuant to the referral decision. Kayishima is opposing his transfer in South African courts. However, a national court does not have the authority to review or challenge the mechanism's decisions. While he has announced his intention to request the mechanism to revoke the decision to refer his case to Rwanda, he has not formally filed a motion seeking this relief. In South Africa, matters remain much the same as they were 2 years ago. Since his first appearance in court in August 23, the case has been repeatedly postponed, most recently until July this year. From my office's perspective, what is imperative is that Kayishima stands trial for his alleged crimes. The victims and survivors have waited more than 31 years now. They should not have to wait any longer. South Africa should immediately execute the mechanism's arrest warrant and transfer Kayishima to the mechanism's custody. If it is unable to do so, it is obliged under the Genocide Convention to prosecute Kayishima in its courts. In both cases, my office believes that the time has come for decisions to be made. The status quo is not sustainable. These matters need to be expeditiously brought to conclusion. Madam President, Excellencies, my office remains fully committed to the implementation of the ISTR and ISTY completion strategies. In particular, we recognize that responsibility for continuing the accountability process has been successfully transferred to Member States. That is why our primary activity is to implement our mandate under Article 28.3 of the Statute to provide assistance to national prosecutions. In the last 6 months, only 11 Member States submitted 177 requests to my office. These requests are increasingly complex as Member States are looking to us for our investigative, analytical, and legal expertise to assist them with resolving challenges in their cases. I would like to highlight 3 notable developments in this regard. First, after concluding our fugitive tracking work, the government of Rwanda requested my office to provide more support to its efforts to account for the more than 1,000 fugitive genocidaires still at large. I am pleased to report that this work is already making significant progress. Earlier this week, we announced with the Prosecutor General of Rwanda that our joint efforts have resulted in additional 65 fugitive files being closed. This notably includes a number of fugitives who we successfully located in third countries. We were also able to identify fugitives whose cases have been processed, whether through extradition or prosecutions in the countries where they reside. Finally, we were able to determine that some fugitives are deceased. Looking forward, we will continue efforts to locate more fugitives, particularly priority cases of perpetrators who bear significant criminal responsibility. Many of them fled Rwanda to seek safe haven in countries across the world where they are enjoying impunity for their alleged crimes. Second, with respect to the former Yugoslavia, 2 months ago we handed over to the Chief Prosecutor of Bosnia-Herzegovina a detailed investigative dossier concerning persons suspected of particularly notorious crimes against humanity. At his request, our officers have established a joint team to conduct further investigations with the aim to prepare an indictment as soon as possible. That joint team, will have its first meetings this week. Similarly, our joint task force with Montenegrin prosecutors continue to achieve progress on the investigative dossier we provided to them concerning Montenegrin nationals suspected of committing war crimes, particularly grave crimes of sexual violence. Third, we are applying the same methodology with other countries as well. I would highlight in particular the continuing excellent cooperation we enjoy with the French Parquet National Antiterroriste, the British Counter-Terrorism Command, and the American Department of Homeland Security. In response to 29 requests for assistance from these 3 countries alone in the last 6 months, we have shared valuable evidence, provided our knowledge of the crimes, and offered advice on concrete investigative steps. Through this and other work, we are helping to ensure that suspected war criminals and genocidaires do not enjoy safe haven in countries where they have falsely claimed refugee status. All our partners report that they continue to have large caseloads to process and are working as quickly as possible. That's why Member States are asking my office to maintain the assistance we provide and strengthen our cooperation. As was planned, national authorities are now in the driver's seat. Ensuring that they receive the support they need will be critical to achieving more results in the accountability process and ensuring that the investment made for accountability continue to provide value. Madam President, Excellencies, finally, in response to the Council's requests, my written report includes some of my office's thoughts following our review of the future of the mechanism and options for the transfer of functions. As my office has explained, in our view, one option is to transfer our assistance to national jurisdictions to another United Nations office. Such a transfer would address both the Council's desire for completion of mechanism functions while ensuring that Member States will continue to receive the assistance that they need. My office will continue developing information and plans to inform the Council's deliberation. More generally, my office has had the unique privilege for many years of working hand in hand with national authorities from around the world, particularly in Rwanda and the former Yugoslavia. We have also maintained close relationships with victims and witnesses. From the very beginning of the completion strategies, we were involved with building domestic institutions, transferring cases and assessing developments. We have seen firsthand how much has changed. From our perspective, the plans envisaged by the completion strategies to bolster national justice efforts have been successfully realized in large parts. That is why we support the principle that where possible, residual responsibilities can be transferred to member states. In our view, over the last 2 decades, member states have delivered justice in accordance with international standards, and the mechanism has always been temporary, while national ownership accountability is the norm. Careful and pragmatic consideration can be given to how to distribute remaining activities between the national but also the international levels. My office will work closely with the Secretary General to prepare the reports that the Council has requested before the end of the year, and we will also continue to participate in cross-organ mechanism planning. In the coming year, we look forward to actively engaging with the Council and are committed to provide all information that will assist the Council. My office remains grateful for the continued support of this Council in all our efforts. I thank you very much for your attention.
I thank Mr. Bramertz for his briefing. I now give the floor to those Council members who wish to make statements. I give the floor to the representative of Sierra Leone.
Thank you, Madam President. I thank George Santana, President of the mechanism, and Mr. Bremers, the prosecutor, for their comprehensive briefings on the activities of the mechanism covering the period 16 November 2024 to 15 March 2025. Sierra Leone acknowledges the mechanism's continued efforts to implement the recommendations of the Security Council contained in Resolution 2740 of 27 June 2024, as well as those outlined in the Office of the Internal Oversight Services report on evaluation of the methods and work of the International Residual Mechanism for Criminal Tribunals dated 27 February 2024. We take note of the mechanism's work to realign its operations with the Council's original vision in establishing it in 2010. Through several efficiency measures, including streamlined court procedures, remote judicial engagement, the use of national judges in the United Republic of Tanzania, adjudication by written submissions, and internal agency cost sharing, the mechanism has succeeded in reducing its operational costs. We further note the mechanism's staffing level, currently at 234, is projected to decrease to 112 by 21st December 2025, reflecting its progressive downsizing in line with its residual mandate. In the area of internal governance, we acknowledge the establishment of a cross-organ working group across the mechanism's 3 organs and 2 branches, enhanced dialogue with the Joint Negotiating Committee, and improved communication with staff regarding restructuring and budget matters, all contributing to greater transparency, accountability, and inclusivity in decision-making. During the reporting period, the mechanism also began compiling information to support the Secretary General's report as requested by the Council in paragraphs 11 and 12 of Resolution 2740, while continuing to deliver effectively on its core residual functions. Madam President, the mechanism's role in enforcement of sentences included 4 applications for early release, 1 decision on sentence remission, and 1 temporary transfer order of a convicted person to the United Nations Detention Unit. As reported, the Office of the Prosecutor continues its assistance to national jurisdictions, supporting 65 cases in Rwanda and 128 in former Yugoslavia, and promoted regional judicial cooperation in the Balkans. The mechanism also actively monitored referred cases in 2 national jurisdictions and reported progress in archival management. We took note of the mechanism's ongoing work to implement the recommendations of the Office of Internal Oversight Services. In addressing the critical issue of released and acquitted persons, we welcome the mechanism's development of an advocacy plan aimed at mobilizing the wider UN system towards a durable solution, particularly concerning the situation in Niger. We encourage the mechanism to continue reporting to the Council on progress made in this regard and on the implementation of the 2 remaining recommendations from the 2024 OIOS report in its next reporting cycle. Madam President, despite noticeable progress, we remain concerned by the mechanism's persistent challenges, particularly the absence of enforcement states and the return of convicted persons to the UN detention unit by certain states, citing domestic legal constraints and other considerations. We reiterate our call upon member states to extend cooperation in addressing these challenges and to support sustainable solutions for relocated individuals in Niger and for the transfer of Mr. Felicien Kabuga to an appropriate enforcement state. On the issue of missing persons, we acknowledge the Office of the Prosecutor's efforts to clarify the fate and whereabouts of 43 individuals. Nonetheless, we note with regret that over 12,000 persons remain unaccounted for. In conclusion, Madam President, Sierra Leone reaffirms its full support for the work of the mechanism and it reiterates its unwavering commitment to the fight against impunity wherever it is found and by whoever it is perpetrated. We note that the mechanism's continued work is not only vital to concluding the legacy of the ad hoc tribunals, but is also instrumental in safeguarding the credibility of the Security Council's role in the administration of international criminal justice. Above all, it upholds the promise of justice for victims, women, men, and children who suffer grievous crimes known to humanity and whose dignity demands accountability. I thank you.
Thank the representative of Sierra Leone for the statement and give the floor to the representative of the Republic of Korea.
Madam President, I thank President Gatti Santana and Chief Prosecutor Bremerich. I also welcome the participation of His Excellency Mr. Nemad Vizi, Minister of Justice of Serbia, and then representatives of Bosnia-Herzegovina, Rwanda, and Croatia. 3 decades after perpetration of the genocide and atrocities in Rwanda and former Yugoslavia, we are reminded of these heinous crimes with the repercussions for international peace and security, and then of our solemn duty to ensure accountability for all perpetrators. Registering our full support for the mechanism's continued efforts, let me highlight following 3 points. First, we welcome mechanism's ongoing efforts to carry out its residual functions amid challenges of downsizing. We take a positive note of the mechanism's completion of the review proceedings in the Untaki Lutimana case, its ongoing monitoring of the contempt case in the national jurisdictions, and its continued efforts to resolve Kabuga and then Kaisema cases. We also commend the mechanism's continued efforts to streamline and downsize its operation while effectively carry out its core residual judicial functions, including review proceedings, sentence enforcement, and witness protection. We trust that the mechanism will remain aligned with the Council's vision of the small, temporary, and efficient institution through the continued implementation of this completion strategy. Second, all relevant members should refrain from hindering mechanism's efforts to assist national jurisdictions. We commend the mechanism's continued efforts to cooperate with Rwanda and the state of the former Yugoslavia in assisting national investigations and prosecutions. These efforts have been notably reinforced by the applaudable cooperation of many member states throughout this process. However, we remain concerned that the relocation of the listed individuals, notably in the case of the Niger, delays in the transfer of the accused persons, and limited cooperation in fugitive tracking continue to hinder the mechanism's effective function for assisting national jurisdiction. As the report rightly underscores, the successful completion of the justice cycle is not possible without the active cooperation of member states. In this regard, we call on all member states to fully comply with the Resolution 2740 and provide the mechanism with the appropriate assistance. Third, the restoration of the justice must be guided by the victim-centered approach. We are deeply concerned about the continued glorification of the war criminals and denial of the genocide taking place in some countries, which pose serious risk to victims and witnesses and jeopardize the integrity of justice. We commend the mechanism's ongoing efforts for judicial protection of the witness and victims, including threat assessments, informing of the release of the convicted persons, and safeguarding confidential information related to witnesses. In order to avoid undermining these efforts, we urge member states to take a response and the resolute action against the glorification and denial to prevent inflicting further trauma on victims. In this regard, we express our support for the OTP's efforts to counter such ideologies through the promotion of education and remembrance. In concluding, Madam President, the Council is expected to receive a Secretary General's report regarding the way forward for the mechanism by the next briefing in December in accordance with the Resolution 2740. We believe this report will provide comprehensive recommendations that ensure the preservation of the mechanism's legacy and enable us to find the best ways to transfer the mechanism's residual functions. I thank you.
I thank the representative of the Republic of Korea for the statement and give the floor to the representative of Greece.
Madam President, I would like to thank President Katis Santana and Prosecutor Brammertz for their comprehensive briefings, and I welcome His Excellency, the participation of His Excellency Mr. Vujic, Minister of Justice of Serbia, as well as the representatives of Bosnia-Herzegovina, Rwanda, and Croatia in this meeting. We wish to underline the following points. First, during the reporting period and the entire 2024, the mechanism conducted its activities by rendering, as underlined in the report, one of the highest numbers of decisions and orders in its life related to judicial functions and enforcement of sentences, a figure reflecting the importance of its role. While international trials for crimes committed in former Yugoslavia and Rwanda have been completed, support to states to investigate, prosecute, and to bring to justice more than 1,000 fugitive genocidaires in the case of Rwanda and an equal number of fugitive war criminals in the former Yugoslavia is a further evidence of the importance of the mechanism. Two cases portray the significance of the work of the mechanism in pursuing justice. They relate to the non-execution of arrest warrants in the cases of Jojic and Radeta and Kayasima, respectively. In this regard, Greece shares the concerns of the mechanism and reiterates the obligations of the relevant states to proceed accordingly. Second, regarding the enforcement of sentences, we wish to highlight the guarantees relating to the conditions of imprisonment stemming from the President's supervisory power, the international standards, and the relevant rules of the mechanism. We underscore in this regard, as underlined in the report, that the International Committee of the Red Cross and the Committee for the Prevention of Torture of the Council of Europe regularly monitor the conditions of imprisonment. This is to ensure that international standards are met and that the relevant recommendations are addressed by both the mechanism and the national authorities of the enforcement states. Third, Greece underscores, as highlighted in the report, that national prosecutions remain essential to achieving justice and to holding accountable the perpetrators of serious international crimes. These are either committed during the Rwandan genocide or committed in the former Yugoslavia. We underline in this regard the strong support of the authorities of Rwanda to the Office of the Prosecutor for its work to assist prosecutors in the country and to other states to locate fugitives, complete investigations, and bring perpetrators to justice. Equally, the report underscores that judicial cooperation in the form of transfer of investigations and indictments between the countries of former Yugoslavia is essential to ensure accountability of war criminals and to address the significant existing gap in this respect. This takes the form of important backlog due to requests not responded, insufficient human resources, or non-efficient and effective proceedings. Against this backdrop and the substantially reduced nature of the residual functions of the mechanism following the conclusion of all core crime cases and all fugitive tracking, the Security Council Resolution 2740 sets out the elements of its future activities, namely its small, temporary, and efficient structure with small number of staff aligned to its reduced functions. Resolution 2740 requested the Secretary General to present an updated report on options for the transfer of the functions of the mechanism relating to the supervision of the enforcement of sentences and to the assistance to national jurisdictions on prosecutions, but also on the administrative and budgetary aspects for possible locations of the archives. We note in this respect the readiness of the mechanism to provide its assistance and views. Equally, we wish to note that the report underscores that the volume and complexity of requests received from national jurisdictions for assistance, as well as the wide range of authorities submitting requests, highlight the important role of international assistance, either through the Office of the Prosecutor or through a future United Nations office in securing accountability of perpetrators of international crimes. To conclude, Madam President, Greece considers essential that the mechanism provides comprehensive input in view of the forthcoming report of the Secretary General on potential options for the future transfer of its functions to achieve justice for the crimes committed and to strengthen the rule of law. I thank you.
I thank the representative of Greece for the statement, and I now give the floor to the representative of Pakistan.
Thank you, Madam President. I thank the President of the International Residual Mechanism for Criminal Tribunals, Judge Santana, and the prosecutor of the mechanism, Mr. Bremets, for their valuable briefings. We also welcome the participation of the representatives of Serbia, Bosnia and Herzegovina, Rwanda, and Croatia in today's meeting. Madam President, Pakistan acknowledges the vital role played by the mechanism in preserving judicial continuity, upholding accountability, and facilitating access to legal records and archives from the International Criminal Tribunals for the former Yugoslavia and Rwanda. We note Security Council Resolution 2740, which extended the mandate of the mechanism for a period of 2 years until 30th June 2026, reaffirming the Council's commitment to an efficient and structured conclusion of its responsibilities. The resolution recognizes the importance of the mechanism completing its work in a timely, transparent, and cooperative manner. The latest reports by the President and the prosecutor offer valuable insights into workforce planning, institutional downsizing, and propose scenarios for the eventual transfer of the remaining responsibilities. These are important for ensuring that the mechanism's drawdown is carried out responsibly and with due regard to legacy functions. Madam President, the reports also highlight progress in key areas such as supervision of sentences, provision of assistance to national jurisdictions, and the safeguarding and digitization of archives. These efforts speak to the professionalism and institutional commitment of the mechanism's leadership and staff. Pakistan values the importance of transparency and cost efficiency. We support continued 6-monthly reporting on the mechanism, which keeps the Council informed of the evolving workload, staffing levels, and exit planning benchmarks. While the mechanism's mandate is limited and transitional, its contributions to the international criminal justice system remain significant, building on the historic work of the ICTY and ICTR in the clarification and further development of international criminal law. Pakistan calls for the continued cooperation of member states, particularly in facilitating enforcement, supporting national prosecutions, and upholding the integrity of legal records. Over the years, 4 Pakistani nationals served as judges on the International Criminal Tribunal for the former Yugoslavia, and 1 served as a member of the appeals panel of the International Criminal Tribunal for Rwanda. Madam President, Pakistan reaffirms its commitment to multilateralism, the rule of law, promotion of justice, and ensuring accountability for the most serious international crimes. There must be no impunity for atrocities committed in any context or under any pretext. The work of the 2 tribunals is also groundbreaking in that it can relate to future accountability efforts, particularly in situations of prolonged illegal occupation, involving brutal suppression of people's right to self-determination and perpetration of mass atrocities. The legal templates, the political precedents, the jurisdictional models, documentation, and evidence gathering, together with victims' participation, are all important and relevant aspects which manifest that international justice is viable with necessary political will, credible documentation, and concerted international attention and advocacy. Pakistan will continue to engage constructively with the Council and other stakeholders to ensure that the work of the mechanism is concluded in a responsible, structured, and sustainable transition. Thank you.
I thank the representative of Pakistan for the statement. I give the floor to the representative of Panama.
Thank you, President. Panama extiende su agradecimiento.
Panama extends its gratitude to the President of the International Residual Mechanism for Criminal Tribunals, Judge Graciela Gatti-Santana, as well as Prosecutor Serge Bramets for their detailed reports. We also welcome the delegations of Bosnia and Herzegovina, Serbia, Rwanda, and Croatia, who have honored us with their presence here today. The International Criminal Tribunal for Rwanda and the International Criminal Tribunal for the former Yugoslavia were undoubtedly 2 of the most relevant institutions over the past decades for international criminal justice. Their work laid the foundation for combating impunity in the face of atrocious crimes, and they honor a fundamental principle that victims, and particularly their family members, are entitled and remain entitled to the irrevocable right to seek justice for the atrocities committed against their loved ones. Today, this invaluable legacy lies with the residual mechanism. President, although not at the pace which the international community would have liked due to the nature and complexity of cases, we do recognize that the mechanism has made consistent progress in reducing its functions. More specifically, given the current worrying context of limited liquidity and financing in major multilateral spaces, we recognize the efforts of the mechanism to reduce its physical infrastructure, including the closure of the External Relations Office, as well as streamlining staff and planning for budgetary reductions. We encourage them to continue with these efforts. Moreover, while the main trials have ended, the report highlights the fact that the mechanism continues to do important work, for which an orderly transfer must be considered. Among these tasks, I would underscore the supervision of sentence enforcement, addressing review of proceedings, protection for victims, the management and the location of court archives, and the support to national jurisdictions by the Office of the Prosecutor. The assistance provided by that office to member states for national investigations and proceedings is an important tool which we must continue to guarantee so that those most responsible will remain accountable before the law. That technical support, which includes forensic analysis, the exchange of information, access to the mechanism's archives, and the transfer of institutional experiences, bolsters the principle of complementarity which underpins the international architecture for criminal justice. For Panama, this type of cooperation fills a major vacuum within the multilateral system because it offers a clear-cut way for states to advance their own efforts to address accountability in the face of atrocious crimes. And therefore, once the mandate has concluded, Panama believes that we should explore the possibility of expanding this model. In this regard, we trust that the United Nations and believe that the United Nations is in a unique position to fill the existing vacuum in the international criminal justice system, including in cases which go beyond those covered by the residual mechanism. In conclusion, Madam President, while Panama acknowledges the important work still being done by the mechanism, we also call for continued and redoubled efforts to ensure a reduction and a progressive, orderly, and efficient transfer of its operations with a view to a permanent closure. Thank you.
I thank the representative of Panama for the statement, and I give the floor to the representative of the United States.
Thank you, Madam President. President Gatti Santana and Prosecutor Brammertz, thank you very much for this briefing on your ongoing work to advance justice on behalf of the victims of atrocities committed in Rwanda and the former Yugoslavia during the conflicts of the 1990s. We appreciate President Gatti Santana and her leadership as the mechanism continues to streamline and downsize its functions. Over 30 years ago, reports of civilian massacres, rapes, and torture in detention sites, along with city attacks, led to the creation of the International Criminal Tribunal for the former Yugoslavia. A year later, the Rwandan genocide prompted the establishment of the International Criminal Tribunal for Rwanda. These tribunals have brought hundreds of perpetrators to justice, established a factual record of the crimes, and challenged the impunity of political and military leaders. However, the advancing age and health of defendants, victims, and witnesses make resolving outstanding cases more urgent. For instance, the mechanism must address Felician Kabuga's release due to his health and Radko Mladic's need for palliative care. We hope the judicial proceedings in South Africa involving Fulgens Kayishema conclude swiftly, allowing him to face trial for genocide and crimes against humanity, providing justice for the victims. Lastly, we note the contempt proceedings that have followed the Nagira Batwari case review process. Justice requires that victims and witnesses remain free from interference, and we expect the mechanism likewise to uphold the due process rights for defendants, ensuring a just resolution. We value the mechanism's support for national authorities in addressing atrocity crimes within their domestic systems. By providing legal, evidentiary, and strategic assistance, the mechanism strengthens the rule of law. In the Western Balkans, the Office of the Prosecutor has provided direct case support and resolved cross-border issues. We welcome the collaboration between Bosnia and Herzegovina, Croatia, Serbia, and Montenegro with the Office of the Prosecutor. and urge continued efforts to resolve case backlogs and deliver justice to victims. The prosecutor's report on Rwanda highlights the ongoing and completed proceedings in France, Belgium, and the recent arrest of Faustin and Sabamukunzi in the United States. These examples show a shared commitment to accountability prevents perpetrators from finding safe haven. We appreciate states supporting investigations, prosecutions, and hosting convicted persons, as enforcing sentences is crucial to the mechanism's work. We remain concerned about the situation of the individuals acquitted or released in Niger and believe they deserve a resolution. As investigations and prosecutions wind down, preserving the legacy of the mechanism and its predecessor tribunals is crucial. We appreciate President Gatti's focus on making public records available and the commitment to preserving and digitizing physical records. We strongly support the mechanism's efforts to engage the public through information centers, workshops, and social media. We value the EU's support for programs in the Western Balkans, which have enabled the mechanism to engage school teachers and bring youth together. Educating the public is essential to combat genocide denial and historical revisionism, especially for the youth who must understand the impact and legacy of past events. Next month, the international community will commemorate the 30th anniversary of the Srebrenica genocide. This is a time to commit to reconciliation and peaceful future grounded in justice and the rule of law. We honor victims, survivors, and their loved ones who should be at the heart of our efforts to promote justice and accountability. The United States will continue to advocate for justice as the foundation for peace and stability. Thank you.
I thank the representative of the United States for the statement, and I give the floor to the representative of Denmark.
Thank you, Madam President. President Gatti Santana and Prosecutor Brammertz, thank you for your comprehensive briefings today and for your continued contribution to achieving international criminal justice. I also wish to welcome the presence of His Excellency Mr. Vucic, Minister of Justice of Serbia, as well as representatives of Bosnia and Herzegovina, Croatia, and Rwanda at today's debate. Last year, we marked the 30th anniversary of the genocide against the Tutsi in Rwanda, and this year we will mark the 30th anniversary of the genocide at Srebrenica. It is your work in the national jurisdictions in Rwanda and the former Yugoslavia that is key to providing justice to the victims and the survivors today. As this is Denmark's first time participating in a council debate on the international residual mechanism for criminal tribunals, let me start by expressing our full support to the mechanism and its important work. The mechanism has made significant accomplishments and continues to play a crucial role in ensuring accountability, ending impunity, and preventing future atrocities. Madam President, allow me to make 3 points. First, I wish to welcome the progress reports presented by President Gatti Santana and Prosecutor Brammertz. We especially want to highlight that the mechanism has now accounted for all fugitives and completed all trials and appeals. This is a major milestone for our fight against impunity and for honoring the victims and survivors of these devastating atrocities. As the brief has made clear, the work is not yet over. The mechanism's assistance to national jurisdictions, including the Prosecutor General of Rwanda and national prosecutors in the former Yugoslavia, continues to be vital for their efforts to investigate and prosecute those responsible for serious violations of international law. As stated in the report, a staggering number of suspected war criminals are still to be brought to justice. In addition, the mechanism continues to play an important role in the protection of victims and witnesses, supervising the enforcement of sentences, preserving court records, and fighting denial of the genocide and other atrocities committed in Rwanda and the former Yugoslavia. Madam President, secondly, we welcome the mechanism's continued efforts to realize the Security Council's vision of a small, temporary, and efficient organization, and to provide assistance to the Secretary General on the reports on the future of the archives and options for the transfer of the mechanism's function. We encourage the mechanism to identify further concrete steps to realize the Council's vision and welcome the concrete suggestions outlined by the prosecutor in this regard. We stress that such efforts must not be at the expense of justice. The core functions of the mechanism must be preserved until it fully completes its mandate. The mechanism's ability to finalize its operation is dependent on the cooperation of states, including the transfer of the subjects subject to arrest warrants. We urge all states to fully cooperate with the mechanism in accordance with their international obligations and to expedite their efforts to enable the mechanism to fulfill its mandate. My third point relates to the preservation of the mechanism's archives. This is crucial, and we look forward to receiving the Secretary-General's report on options in this regard. The archives are not only essential for ongoing national authorities' investigation and prosecution efforts, but also to ensure that the crimes of the past are neither forgotten, distorted, or repeated. The archives will serve as a testament to the legacy of the ad hoc tribunals and as an essential resource for education and prevention of atrocities. We underscore that the future location of the archives must be one that secures this objective. Let me conclude by reiterating Denmark's steadfast support for international criminal justice and our unwavering commitment to supporting the Council's efforts to combat impunity wherever it exists. Thank you.
I thank the representative of Denmark for the statement and give the floor to the representative of China.
President. China thanks President Gatti Santana and Prosecutor Bramers for their briefings. We welcome the Minister of Justice of Serbia and also the representatives from Bosnia-Herzegovina, Rwanda, for their participation in today's meeting. Chair, during the reporting period, as mandated by the Security Council Resolution 2740, the mechanism proceeded with the supervision of sentenced individuals, relocation of persons released, and promotion of the work of the mechanism, among its other residual functions, in an orderly manner with positive progress, which China acknowledges. Regarding the mechanism's work going forward, China would like to make the following points. First, the mechanism should, under the Council's Resolution 1966, stick to its original positioning as a small, temporary, and efficient institution, with its functions and scale progressively reduced over time, actively implement the recommendations of the Informal Working Group on International Tribunals and the UN Office of Internal Oversight Services, continuously optimize resource allocation, reduce functions and size until its Security Council mandate is completed in full. Second, according to the report of the President of the mechanism has completed all core judicial cases. However, there is still redundancy in the relevant institutional arrangements and staffing. Therefore, the three main organs of the mechanism should be further streamlined. In particular, the registry should close unnecessary offices and downsize unnecessary staff. Third, as an organ established by the Security Council, the mechanism should leverage the UN80 initiative to press ahead with its own reform, come up with pragmatic and reasonable recommendations on monitoring the enforcement of sentences, providing assistance to national jurisdictions, and preserving relevant archives, among others, and create conditions for the transfer of functions to states or UN entities. Last but not least, China supports the mechanism's completion of its unfinished work and historical mission as soon as possible. I'd like to take this opportunity to thank Sierra Leone, Chair of the Informal Working Group, and the Office of Legal Affairs of the UN for their work in coordinating the Security Council with the mechanism. I thank you, President.
I thank the representative of China for the statement and give the floor to the representative of Algeria.
Thank you, Madam President. At the outset, I would like to thank Judge Graciela Gatti Santana, President of the International Residual Mechanism for Criminal Tribunals, namely ICTR and ICTY. I thank her for her comprehensive presentation of the biannual progress report that covers the activities of the mechanism from the period 16 November 2024 to the 15th of May 2025. Pursuant to Resolution 1966 of 2010, adopted by the Security Council. I would also like to thank Mr. Serge Brammertz, prosecutor of the mechanism, for the presentation submitted today in accordance with paragraph 10 of said resolution. I would also like to welcome the presence of the representatives of Rwanda, Serbia, Bosnia and Herzegovina, and Croatia to this meeting. My delegation takes note of the progress made during the reporting period, whether in the area of the enforcement of sentences, the protection of witnesses, or assistance provided to national jurisdictions. We also note the effort made by the mechanism and the president of the mechanism to streamline resources and reduce the size of the mechanism. Madam President, we would like to reiterate that the establishment of this mechanism from day one was of an exceptional and transitional character, and that Resolution 1966 of 2010 stressed that it should be small, temporary, and efficient structure for residual functions whose functions and size should diminish over time, in accordance with specific and reasonable timelines. Today, after more than a decade since its establishment and with core cases coming to term, we think that the conditions are conducive to transition towards the final and last stage of the functions of the mechanism in a responsible manner, namely the gradual and orderly closure of the mechanism. In this regard, Algeria stresses the following points. 1. The need to respect a main principle of international law, namely the inherent jurisdiction of states to try crimes committed on their territory or by their citizens, which reflects the principle of sovereignty as enshrined by the UN Charter. 2. Stressing that universal jurisdiction cannot be a substitute to national jurisdiction. Instead, it should be complementary and reinforce it in cases of inability or substantive reasons within the framework of clear requests and voluntary cooperation. 3. Promoting the principle of complementarity with national jurisdiction systems through supporting the state's abilities to try international serious crimes punishable under international law as part of national jurisdiction. 4. The need for the mechanism to intensify effort to conclude residual functions as soon as possible in coordination with the Secretariat without prejudice to due process, and supporting the transfer of residual functions, including monitoring the enforcement of sentences, providing assistance to national judiciary and jurisdiction, archive management, and cooperation with affected states to establish information and documentation centers as set forth in Security Council Resolution 2740 of 2024. 5. Stressing that cooperation with the mechanism needs to remain governed by international law and the principle of state consent, without imposing judiciary arrangements that are not accepted by the concerned affected states. 6. Ensuring continued access to international justice archives through maintaining the archives of the ICTY and ICTR and providing access to concerned authorities in affected states. This would maintain collective memory for the benefit of future generations and combat impunity and address attempts to deny serious crimes or glorify perpetrators. In closing, Algeria, based on its principled commitment to the principles of justice, accountability, and combating impunity, stressed that mutual respect and complementarity between international mechanisms and national jurisdictions are a basis for justice and the rule of law at the international and national levels. We believe that concluding the functions of the mechanism in a coordinated, orderly and transparent framework is part of this track. We will remain committed to working with all members of the Council to support this period of transition. I thank you.
I thank the representative of Algeria for the statement and give the floor to the representative of the United Kingdom.
Thank you, Madam President. And let me begin by thanking President Gatti Santana and Prosecutor Brammertz for the reports to the Council today. And we also take this opportunity to thank the staff of the mechanism for their ongoing commitment to the work of the institution. I would also like to welcome His Excellency, the Minister of Justice of Serbia, as well as the distinguished representatives of Bosnia and Herzegovina, Rwanda and Croatia to today's Council meeting. Madam President, I will make 4 points today. First, as the President of the mechanism rightly noted in her remarks today, the upcoming 30th anniversary of the genocide at Srebrenica reminds us of the significance of the work which the mechanism has undertaken. An important work continues, with the mechanism continuing to perform important judicial, prosecutorial and operational functions as part of its ongoing work. Second, state cooperation with the mechanism remains essential, and we welcome the support that states continue to provide. The UK will continue to play its part, including through the enforcement of a number of sentences of imprisonment of persons convicted by the mechanism or its predecessor institutions. We welcome the President's request for states to give serious consideration to enforcing the sentences of imprisonment of persons currently housed in the UN detention unit in The Hague. And we call once again on Serbia to ensure the arrest and transfer of Petar Jojic and Vjerica Radeta to the mechanism. Third, the President made reference in her remarks today to a case in the UK relating to a judge from the mechanism roster. The UK would like to thank the Secretary-General for the prompt action taken to waive immunity and for the close cooperation that UK and UN officials took to keep each other updated on the case. Fourth and finally, as we look to the future, it is important to have regard to the broader context. This includes both the mechanism's status as a residual institution and the financial challenges facing the United Nations more broadly. There will therefore continue to be a need for rigorous budgeting and efficiency in all UN bodies, including at the mechanism. In this context, we welcome the measures that the mechanism has taken to maximise efficiency as outlined in the reports. We are also pleased to hear of the ongoing cross-organ consultation on options for the location of the archives and for the transfer of certain other functions. We encourage the mechanism to continue and to deepen such work over the period ahead. We look forward to seeing more detailed proposals in the Secretary-General's reports later in the year. These will be helpful as we work to deliver the vision of the mechanism as a small, temporary and efficient institution. Madam President, to conclude, the UK remains a steadfast supporter of the mechanism's work and of its role in delivering justice. Thank you.
I thank the representative of the United Kingdom for the statement and give the floor to the representative of the Russian Federation.
Madam President, the regular reports from the International Residual Mechanism for Criminal Tribunals to the Security Council is one of the subjects which divert the Council's attention from genuinely important items on its agenda. Today's meeting should have served as a platform for the discussion of practical issues related to the closure of the mechanism, which has already concluded its judicial and prosecutorial functions. Instead of this, time and again, these meetings are being used to demonstrate the fact that even today, where the United Nations is beset by a financial crisis, where there are proposals for significant cuts, the mechanism, which is no longer relevant, is proposed to remain unchanged with a staff of 234 positions and a budget of $61 million. Let us recall that the mechanism was established 15 years ago by the Council as a small, purely temporary structure with a small number of staff. This language is enshrined in the specialized resolution dating 2010. Let us look for a comparison. For example, the International Maritime Organization has 300 international staff. The International Court of Justice, the principal judicial body of the United Nations, which has more than 20 cases on its docket, in addition to advisory opinions, has approximately 100 staff. And at the same time, nobody has ever decided that the above-mentioned organizations shall be small or temporary. And in this way, the mechanism, the residual mechanism, providing reports to the Council is simply making a mockery of the instructions from the body which established it. We would like to note that 234 positions at the residual mechanism is not an exhaustive list. There's a strange postscript in the report about this figure not including a number of positions, including staff who are engaging with the Office of Internal Oversight Services. In this way, we do not have a full knowledge of how many staff the mechanism has. This is a blatant intent to mislead the Security Council. We do not agree with this state of affairs against the backdrop of the liquidity crisis plaguing the United Nations and the initiative of the Secretary General for a 20% cut in personnel and budget in all, and I stress, active, not residual areas of work of the United Nations. A temporary and residual structure needs to close in order to free up resources for priority objectives of the United Nations, first and foremost, the maintenance of international peace and security. This is easily achieved. There's a need for the Council to take a decision to distribute among current UN departments and member states the small number of residual functions which the mechanism itself has been carrying out exceedingly poorly. The report of the prosecutor has similar proposals which warrant close consideration. And we would note separately the recognition that the function for victim and witness protection has de facto been handed over to states, and we have long been discussing this. We expect greater details and specifics about this in the next report. However, the President's report does not even have a hint. Not even a hint about concrete options for handover functions, not even a hint of an intention either to conclude the work in principle. Instead, it is proposed that council members extend the existence of the mechanism in order to carry out supervision functions for the enforcement of sentences that is up until the period after 2040. This is not an acceptable approach, especially against the backdrop of the utter inability of the mechanism to carry out these monitoring functions. Enforcement states, such as the United Kingdom and Estonia, continue to disregard even the United Nations standard minimum rules for the treatment of Serb prisoners. These are the so-called Nelson Mandela rules. They are barred from visiting and meeting with relatives or lawyers. The visas are not being granted for such purposes. They are prevented from using the telephone, from using the internet. Their banking accounts and transactions are being blocked. They are not being provided with adequate medical assistance. Applications for early release following the serving out of 2/3 of their sentences are being denied, and they are being targeted by acts of psychological and physical violence. We have specific examples that we will share with you. For example, the 79-year-old Radovan Karadzic, who is serving out a sentence in the territory of the United Kingdom. For 4 years, he has not been visited by his family, and they have been systematically denied entry visas. The payment of fees for the services of a lawyer who has a license to work in the United Kingdom is also something that the British authorities have denied. And so Mr. Karadzic has been stripped of any ties to the outside world, and his right to defense has been denied, and this is being done in order to continue to violate his rights with impunity. The prisoner is suffering from diabetes, and yet he does not receive a special diet that is appropriate for his condition. He has been stripped of access to vital medications. As a result, his health, the state of his health, is continuously deteriorating. Given the advanced age and the serious condition of this Serb, the penitentiary administration, under the pretext of allegedly his preparing to flee, has been imposed so-called enhanced security measures against Mr. Karadzic. These measures essentially constitute torture. In his cell, the light is constantly on, including during nighttime. And let's recall that forced sleep deprivation through the use of electricity, electrical light, or sound is torture. We have drawn the attention of the mechanism to the situation half a year ago. We called upon the mechanism to fulfill its oversight functions and monitoring functions and to visit the prison. This, however, was not done. The president of the court generally trusts the word of London. If London says that they are not committing any violations, then there is no need to verify. There are continuous violations of the rights of Milan Lukic, who is serving out a sentence in Estonia, who filed an appeal to the mechanism, and these appeals were denied. And moreover, in April of this year, another convicted person, Radislav Kristic, who will be brought over to Estonia to serve out a sentence. Mr. Kristic survived an attack by fellow prisoners in a British prison, and his leg was amputated. What is noteworthy is, as we are aware, both of these imprisoned persons are being held in Estonian prison in Tartu, where there are plans to bring 600 convicted persons from Sweden under a bilateral agreement. It appears that Estonia has decided to make a name for itself as the prison capital of the world. Local rights defenders are sounding the alarm. Will such a large number of prisoners massed together not impact the conditions of their serving out the sentences? For whether or not the mechanism is aware of this problem, this remains unknown because nothing is mentioned about this in the report. And this is how the oversight and supervision functions are being carried out. Let us turn now to what is taking place at the UN Detention Unit in The Hague, which is under the direct oversight of the residual mechanism. The Serb General Ratko Mladic, who is serving out a sentence there, is virtually immobile. He is suffering as a result of heart and kidney issues, the swelling of the heel bone, infected bed sores. He has lost a body weight of 51 kilograms. The bed sores, and I do need to stress this, is an indication of a lack of basic normal care. There's a high risk of heart failure, thrombosis and embolism, as well as sepsis as a result of the bed sores. The medical personnel do not speak Serbian, and they are unable to provide day-to-day care nor timely medical assistance. According to the data that we've received from his relatives, treatment in his current condition is also at present virtually impossible. He effectively requires palliative care, which is not being provided to him. According to Mr. Mladic's SIN, since September 2024, medical personnel have urgently insisted that he consent to a do not resuscitate order in the event of a threat to his life, and apparently they are now alleging that the general consented to this. His relatives, given the dementia that has been diagnosed for Mr. Mladic, they believe that medical personnel are exploiting his vulnerable condition. In light of the above mentioned, we believe that it is highly inhumane that the president of the mechanism in 2024 decided to deny the application for his early release on humanitarian grounds, or to provide opportunity for him to serve out the remainder of his sentence in Serbia. That too was denied. This approach stands in stark contrast with the treatment of Mr. Kabuga, whose case was indefinitely suspended due to the state of his health. We demand that the mechanism immediately reconsider the decision about Mr. Mladic and transfer the general to Serbia to serve out the remainder of his sentence. Let us stress that all responsibility for any possible negative developments will be borne by the mechanism and the president thereof. The convicted persons were sentenced to imprisonment, not to death after many years of torture under the oversight of the United Nations. Against this backdrop, the only option that can guarantee the very basic rights of Serbian prisoners is their expeditious handover to the state of their citizenship to serve out the remainder of their sentences. And for the remaining functions, this is precisely the most realistic option. We call upon the leadership of the mechanism in the next report to the Council, as well as with the report of the UN Secretary General, to provide the corresponding detailed, practical, and feasible proposals for the handover of all residual functions that will make it possible to completely wrap up its operations. There is no need to include in the report already options that have already been rejected. These include the establishment of the so-called omnibus residual mechanism for all ad hoc tribunals, or the handover of cases to the so-called International Criminal Court. We wish once again to caution against attempts to artificially extend the lifespan of this structure by initiating new so-called contempt of court cases. Madam President, the mechanism is a successor of the infamous ICTY, which entered into history with its iniquitous approaches, its double standards, and its politicization. In March, we were surprised to learn that in the United Kingdom, one of the judges of the mechanism received a criminal conviction, convicted to 6 years, 4 months imprisonment for engaging in the practice of modern-day slavery. And we would note separately that informing the Council about such issues post facto, after everything has already transpired, is not only an exceedingly unprofessional approach by the residual mechanism, but this also constitutes a deliberate cover-up of the complicity of a judge in crimes. On the whole, the situation only reflects the fact that the mechanism's claims to some kind of a legacy and lofty standards have no leg to stand on. It should be clear to all members of the Security Council that the mechanism can no longer continue to exist, and it needs to be shuttered. Thank you.
I thank the representative of the Russian Federation for the statement and give the floor to the representative of Slovenia.
Thank you, Madam President. I'd like to thank Judge Gati Santana and Prosecutor Brammertz for the detailed progress report submitted to the Council, as well as for their briefings today. I also welcome the representative of Bosnia and Herzegovina, Croatia, Rwanda, and Serbia to the meeting. Madam President, let me begin by reiterating Slovenia's continued support for the mechanism. Despite being in its residual phase, its work remains crucial for the fight against impunity. The ICTY and the ICTR have been established by this Council because the Council members understood and agreed on the importance of this fight. Today, thousands of victims and survivors and their families wait for justice in many conflict and post-conflict situations. States concerned must deliver, and the fight against impunity has to continue. Madam President, the mechanism is nearing its completion and has been in truly residual phase for the second year. We welcome all the efforts made by its leadership and the systematic approach to identifying key remaining tasks, downsizing and streamlining mechanism's functions while still fulfilling its residual work. The responsibility now lies with the states to continue the fight against impunity at the national level. We commend all efforts undertaken to deliver justice and ensure that perpetrators are held accountable. In this regard, we cannot stress enough how important cooperation among states is. In addition, we note the increasing number of requests for assistance made by states to the mechanism and the prosecutor, and we welcome the continued support both of them extend to the requesting states. This residual function needs to continue even after the termination of the mechanism. That includes ongoing support for regional cooperation, which remains vital for ensuring effective judicial proceedings in the countries of the former Yugoslavia. The other crucial residual function is the management of the archives. The historic record of what happened, as well as the work and decisions of the tribunals and the mechanism, must be preserved and made accessible to future generations, so that history might continue to serve as a teacher and a warning. We expect the Secretary General's report at the end of this year to adequately address both of these core functions, along with other residual functions that must continue. Madam President, I wish I could say that the crimes against humanity, war crimes, aggression, and genocide are things of the past. They are not. And because of that, the legacy of both the ad hoc tribunals and the mechanism are extremely important. Their legacy stands as a powerful symbol of what the international community can achieve when political will aligns with the understanding that justice is essential for reconciliation and lasting peace. It sends the strongest possible message that no one is above the law, regardless of their power or position. It is also a symbol and a sliver of hope for all the victims everywhere, the hope that we will not forget. Next month, it will be 30 years since the Srebrenica genocide, and we do remember. War crimes and crimes against humanity were committed. Genocide was committed. Denying it while glorifying criminals is both reprehensible and unacceptable. Nothing can change these facts, and nothing can erase this history. We will not forget, and for that we owe a deep gratitude to the mechanism, to the ICTY, and the ICTR. I thank you.
I thank the representative of Slovenia for the statement and give the floor to the representative of Somalia.
Thank you, Madam President. At the outset, I would like to thank President Santana, Prosecutor Bramett, for their comprehensive and insightful briefing on the activities of the International Residual Mechanism for Criminal Tribunals. We also welcome the distinguished representative of Bosnia-Herzegovina, Croatia, Rwanda, and Serbia to this meeting. Madam President, Somalia considers this debate to be of paramount importance as it provides the Security Council with the necessary information to make informed decisions regarding the function and the future direction of the mechanism. We commend the mechanism's diligent efforts in implementing Resolution 1966 and for the finally assuming its fully residual functions as originally envisioned by Resolution 1966 and Resolution 2637. We note the significant progress made in the mechanism's work, especially the conclusion of all core crimes and the successful trials of all indicted individuals. This marks a definitive transition toward its residual phase. We also appreciate the efforts to eliminate the duplication of functions among the mechanism organs, leading to reductions of expenditure. The enforcement and review of sentences are a crucial component of accountability efforts and must be carried out in accordance with international standards. We acknowledge the mechanism's ongoing challenges in fulfilling its mandate, particularly concerning the enforcement of sentences and the relocations of acquitted and released persons. Cooperation between the mechanism and member states is fundamental for the proper understanding of its function, especially in the areas of supervision, enforcement of sentences, and the relocation of acquitted and released persons. The residual functions are as crucial as the ad hoc functions of the tribunal that preceded the IRMCT. In this context, we take note of the comprehensive draft framework document submitted by the mechanism to the informal working group of international tribunals, which provides scenarios and projections for the completion of the mechanism's functions. Madam President, in conclusion, Somalia reiterates its support for the work of the mechanism and its tireless effort to achieve justice for the victims. The establishment of justice and the rule of law based on the principles and purpose of the Charter of the United Nations is an essential element in providing accountability under international law and achieving stability and reconciliation at the national level in a manner that promotes international peace and security. I thank you.
I thank the representative of Somalia for the statement and give the floor to the representative of France.
Merci, Madame.
Thank you, Madam President. Madam President, I'd like to begin by thanking the President of the International Residual Mechanism for Criminal Tribunals, Ms. Graciela Gatti-Santana, and for the introduction of the 26th biannual report in accordance with Resolution 1966. And I also thank Prosecutor Mr. Brammertz for his briefing. The orderly conclusion of the ICTR and ICTY activities, the preservation of their legacy, and the fight to combat impunity, which they have ensured and continue to ensure, involves a three-pronged responsibility: that of the Council, that of the mechanism, and that of Member States, and I will refer to each of them in turn. Firstly, it is the responsibility of the Council to be up to the decisions it took 30 years ago in establishing the ICTR and ICTY as instruments to combat impunity. These decisions imply long-term responsibilities to the victims, to those accountable, and to future generations. It is these responsibilities which the mechanism addresses by ensuring the residual functions of the tribunals which preceded it. Secondly, it is the responsibility of the mechanism to carry out the expectations of this Council regarding the way in which it works and how it prepares the transfer of some of its functions. Although there are no longer any fugitives accused of major crimes, the mechanism has now entered the second year of its residual phase, and it has acted accordingly by reducing its staff by 50%, its budget by $21 million between January 23 and January 25. We expect these efforts will be continued as it prepares its budget for 2026. We also note with satisfaction that the three bodies of the mechanism are prepared to contribute to drafting the Secretary General's report expected by the end of the year. Important decisions will indeed need to be taken on a number of issues regarding the key functions such as assistance to national jurisdictions, the protection of victims and witnesses, supervising sentence enforcement, the management of archives, and memory work. In this regard, France will be guided by a basic principle: it is the functions which must continue, not the administrative structures. Among these tasks, we would point out the assistance to national jurisdictions. That deserves particular attention, as underscored by the prosecutor, given the numerous proceedings still underway at the national level for crimes under the ICTR and the ICTY. We also welcome the launch last March of a new assessment by the OIOS, and the results should be known by the beginning of 2026, and they could shed some useful light on the decisions to be taken by the Council in the framework of renewing the work of the mechanism with a view to renewing the mandate in 2026. And thirdly, France recalls the responsibility of member states to cooperate with the mechanism in accordance with their international obligations. We regret that some states still refuse, despite numerous appeals by the President, the prosecutor, and a number of member states here within this Council. Conversely, we welcome the commitment of states where those convicted are serving out their sentences. I'm referring particularly to Estonia with the transfer of Radislav Kurcic in April 2025. Estonia is now shouldering the responsibility of housing 4 convicts under the responsibility of the mechanism. We also welcome the arrest 2 years ago of Fulgence Kayishema, thanks to the cooperation between the Office of the Prosecutor, the authorities of South Africa, and authorities of other countries. This is an example of effective and efficient international cooperation in combating impunity. Finally, Madam, we welcome the efforts of the mechanism to establish in and with the countries concerned information centers. These will be essential for preserving the legacy of the tribunals and combating genocide denial, historic revisionism, and the glorification of convicted war criminals. Thank you.
I thank the representative of France for the statement. I shall now make a statement in my capacity as the representative of Guyana. I thank the President of the International Residual Mechanism, Judge Graciela Gatti Santana, and Prosecutor Sergei Bramertz for their briefings. I also welcome the representatives of Bosnia and Herzegovina, Croatia, Rwanda, and Serbia to today's meeting. Guyana takes positive note of the 26th report of the International Residual Mechanism for Criminal Tribunals and reiterates our support for the continuing work of the mechanism in carrying out essential residual functions for the International Criminal Tribunal for Rwanda and the International Tribunal for the former Yugoslavia. We welcome the further steps taken by the mechanism during the reporting period to reduce its functions. We are also encouraged by the President's refinement of her key priorities following the adoption of Resolution 2740 in 2024. We note in particular the significant reduction of staffing levels, budget, and operational footprint as part of efforts to expeditiously complete the remaining functions of the mechanism. Guyana reiterates its concern that the situation of the persons relocated from Arusha to Niger in December 2022 remains unresolved. We note the continued efforts of the mechanism towards finding a solution and urge states to cooperate and render all necessary assistance to the mechanism pursuant to Resolution 2637. The management of the archives and records of the court are of great importance to preserving the legacy of the ad hoc tribunals and of the mechanism. We look forward to the recommendations in this regard to be presented by the Secretary General at the end of 2025. We take positive note of the progress by the mechanism in implementing outstanding recommendations made by the Office of International Oversight Services and look forward to the closure of the final 2 recommendations. Guyana commends the efforts of the mechanism to respond to requests for assistance from national jurisdictions, thereby enabling them to advance justice and hold perpetrators to account. In closing, Guyana reaffirms its full support for the work of the mechanism and to efforts to combat impunity and achieve justice for the victims of the atrocities committed in the former Yugoslavia and Rwanda. I thank you. I now resume my function as President of the Council. The representative of the United Kingdom has asked for the floor to make a further statement. I give him the floor.
Thank you, Madam President. It's just to respond briefly to say that there is no truth in the accusations made earlier in the debate of mistreatment of any prisoners in our care. The UK was delighted that the President of the mechanism was able to visit the UK in October to see for herself the responsible manner in which the United Kingdom is undertaking its obligations towards the mechanism. Thank you.
I thank the representative of the United Kingdom for the further statement. I now give the floor to His Excellency Mr. Nenad Vučić, Minister of Justice of Serbia.
Thank you, Madam. Madam President, distinguished member of delegations. It's my honor to have opportunity to address the United Nations Security Council on behalf of Republic of Serbia regarding the 6 months report of the work of mechanism and present position of Republic of Serbia. Since the conclusion of a 2-decade-long proceeding in a case of Stanisic and Simatovic, the Hague branch of the mechanism has been positioned to perform exclusively residential function. This is not justification to avoid fulfilling goal established over 15 years ago by Resolution 1966, which intend to mechanism to be small, temporary, and effective structure which function and size will diminish over time. Unfortunately, this report in these previous reports does not demonstrate significant progress toward achieving the goal, reaffirming the Resolution 2637. The current report does not differ substantially from previous ones. the same issue are raised and the same matters to which Serbia was long pointed at the absence of the mechanism president's and prosecutors' report, which the conclusion of the trials concerning the serious violation of international humanitarian law, the mandate of mechanism is in practice completed. In accordance with the view of Security Council, the conduct of relevant judiciary proceedings should be entrusted to national jurisdiction. In this context, we also recall the obligation set for the Resolution 2637/2022, which clearly stated that the Security Council calls upon the mechanism as a part of its completion strategy to provide option regarding the transfer of its remaining activities in a due course. In this context, allegations once again being made against Serbia for failing to cooperate with mechanism due to the non-transfer of the Jojic and Radeta. There is no need to repeat here details presented at previous Security Council session or the reason why the annulment of mechanism decision to refer the case for judiciary of Republic of Serbia is unacceptable. Serbia conduct regrets the case does not consist the violation of its international obligation, as claimed by the president of the mechanism, but rather represent of effort of act on according to Security Council Resolution 1966. The mechanism decision is based on unfounding findings in which both Security Council and the mechanism have been informed. The further supported by testimony of a witness concerning the event of 29 September 2021, which representatives of mechanism subjected the witness of the verbal attack and intimidation of attempt to force the appearance at the witness before the mechanism. Such conduct by person acting on behalf of mechanism in this insistence as amicus curiae assistance should not be tolerated. We are not aware of any action taken by mechanism regarding the conduct of its representative, despite having raised these concerns multiple times during Security Council session, rewriting previous periodic report of the mechanism. The fact that annulment of decision to transfer the case of Jojic and Radeta to the jurisdiction of Judiciary of Serbia is unfounded is also shown by the fact that much more serious cases that to Vojislav Šešelj was referred to the Republic of Serbia, the trial is begin conduct in a proper and lawful manner. Furthermore, we have noted that report that the complete authorities of the United States were requested to provide appropriate position regarding the trial for contempt the court against Peter Robinson, one of the defense counsel before the mechanism. This case directly concerns the mechanism and the interpretation of obligation of the Council before mechanism, which are definitely more specific, these before national courts. The Republic of Serbia is willing to assume jurisdiction over the cases concerning contempt of a court and give the false testimony. At the same time, its position out of numerous prosecution witnesses have abused their situation as a witness of or provide false testimony, which has not resulted in any proceedings for a competitive court or give the false testimony being intent. On the founding of a president of a mechanism is to decide or request for pardon or commuting sentence in accordance with Article 26 of Statute of Mechanism. The former president of a mechanism, Judge Agius, fundamentally altered the long sentencing practice, both ICTY and mechanism, avoiding the prosecutor's position, despite the fact that prosecutor's role is not to intervene in decision on these matters. The significant tightness of coordination for the early release and establishment of provisional release during the period in office of Judge Agius have been subjected sharp criticism. According to one of previous report by the prosecutor of mechanism, these stricter conditions for early release and provisional release resulted from the prosecutor efforts, even through the prosecutor's role in the decision-making process should be extremely limited, consisting only of providing relevant information of the convicted person, cooperation with the prosecutor office. As a result of these changes in a practice, mechanism has gone from around 82 approval rate for early release in a period 1999-2018 to about less than 12% for a period 19 to 25. The release were justified with humanitarian reason, and in one case, release in just 3 days before death. In other words, the convicted who reached the threshold of 2/3 of his sentences before 2019 had a prospect to being released, with the same threshold no longer create the minimum expected chance today. Such abrupt reversal is not result of amendment of a state nor or Security Council resolution, is a result of international arbitrary reinterpretation of Article 26 Statute of Mechanism. It created without transitional measures double standards among prisoners who are concrete compatible case, which means it's against Rule 151, the equal treatment in a similar situation. This is a violation of the principle of equal under Article 26 of Statute, Rule 151 of a Rule of the Procedure and Evidence of a Mechanism, and Article 2, 4, 87 and 108 Mandela rules that require not discrimination ground of the gradually return to the society, including post-sentencing logistic. Nevertheless, despite all this, we provide assurance that the condition for early release or provisional release for which Serbian issue guarantees will be fully respected. For over decades, Republic of Serbia has expressed before this Security Council its willingness to accept convicted person from ICTY or mechanism to serve sentence in Republic of Serbia. Unfortunately, neither the president of mechanism nor the prosecutor consider it appropriate to address Serbia request in their extensive reports or a statement before Security Council, whether by accepting it or by providing reason for its rejection. On this occasion, we repeat the request and express the readiness of the Republic of Serbia to enforce prison sentence imposed by International Tribunal and the mechanism with the Republic of Serbia under the supervision of a mechanism. I would also like to this opportunity to draw attention to the particularly difficult situation of convicted persons serving their prison sentencing in Estonia, UK and Hague. In particular, I must emphasize the serious health condition of the General Mladic and ongoing request before mechanism to temporarily release him from treatment for humanitarian reason. Since he is obviously not receiving adequate treatment in the prison in The Hague, that is why Serbia is asking for and his give all the necessary guarantees for his early release. Therefore, I ask the Security Council to take into consideration serious health condition of General Mladic and as the highest body of the international community take acts towards humanitarian release. Their positions is not in according with the United Nations standard minimum rules for a treatment in a prison. It's obviously due to lack of health issue, language barriers, and remote location where the sentence are being served. Access by family members is significantly hindered, as is the communication between the sentenced individuals and the prison administration and staff, thereby making difficult the provision of adequate medical and legal assistance. The mechanism has concluded trials concerning serious violation of international humanitarian law, as well positioned to provide substantial support to the national judiciary. Given its extensive documentation and numerous testimonies, however, the mechanism must duly recognize that prosecutors and judges operating with the national judicial system exercise full independence in their work, and their decision must not be influenced on political consideration or their demands for the mechanism prosecutor office. The prosecutor's office of the mechanism hold no authorities over national jurisdiction institution, regardless of the political satisfaction or dissatisfaction with their performance. The prosecutor office is noted in a previous report, mentioned example of a certain individuals located in Serbia against whom proceedings have been or been conducted in Bosnia and Herzegovina. Regarding Novak Djukic, the process of the recognition of the enforcing foreign judicial decision in Republic of Serbia is ongoing. The High Court in Belgrade has requested the case files from Bosnia and Herzegovina in order to establish whether the fair trial was conducted. To date, Bosnia and Herzegovina has not provided the requested documents. On the other hand, Novak Djukic condition is such that in November 2024, panel of experts decide he is incapable for following trial proceedings. The regarding of Milomir Savcic, War Crime Prosecutor Office of the Republic of Serbia has initiated the case currently in pre-investigation phase since the case has been initiated. The Republic of Serbia, no person who was perpetrated criminal act shall be granted asylum or shelter. However, in absence of sufficient evidence indicated a responsible suspicion of such an act, criminal procedure shall not be initiated. Furthermore, regarding of other issue raised in the prosecutor's report that fall outside of justification, we cannot work on the fact war criminals responsible for numerous atrocities committed during the 90s. Conflicts are glorified by having airports, squares and streets, name of them, not in Serbia. The main airport in Croatia, bears name Franjo Tuđman, while numerous locations in Bosnia and Herzegovina are named Alija Izetbegović. The situation in Kosovo and Metohija included the glorification of terrorists and perpetrators of responsible for persecution of the Serbs population go without saying, despite it being territory under UN administration. The prosecutor office has never condemned this practice. The prosecutor, in report, highly work on ICTY and mechanism prosecutor office as foundation of the further trials. However, the prosecutor office is largely responsible for fostering condition of impunity, particularly for crimes whose victims were members the Serb people. In the word reporting acquittals, for example, the Haradinaj for serious crime in Kosovo and Metohija, Naser Orić for serious crime in the Podrinje region and Bosnia and Herzegovina, and Ante Gotovina for serious crime in present-day Croatia, also constitute the legacy of mechanism which has significantly reinforced the policy of impunity for crimes committed against the Serbian people in Kosovo and Metohija, Croatia, and Bosnia and Herzegovina. The legacy of the ICTY and mechanism prosecutor office is such that it greatly hinders the realization of justice. The shortcomings in the prosecutor's work over past decades cannot be resolved by programs promoting the so-called achievements of a mechanism. Had the Tribunal Prosecutor Office acted in the interest of justice, these matters would not be discussed before the UN Security Council. No one is above the law. It doesn't mean to the matters when the Serbs are victim. We have a message from a mechanism. The extensive case files of Serbian prosecutorial and judicial authorities demonstrate Serbia's serious and dedicated regarding the persecution of serious violation of international humanitarian law. On the other hand, professionally and academically ground sharp criticism of the mechanism and ICTY, particularly the role of a prosecutor's office in these tribunals, must not be suppressed. Thank you.
I thank His Excellency Mr. Vučić for his statement. I now give the floor to the representative of Bosnia and Herzegovina.
Thank you, Madam President, for giving me the floor. Wish you a successful presidency of the Council for the month of June. I also thank the President of the Mechanism, Judge Gati Santana, and the prosecutor, Mr. Serge Bramec, for their briefings delivered today on the progress of their work, as well as assessments and projections related to it. We remain committed to our support for the ongoing work of the mechanism, particularly those functions that are essential for the entire enterprise to come full circle, and find it crucial to ensure its credibility and legacy and properly upheld and preserved. Continued engagement in enforcement of sentences, as well as the matter of archives and the state of full digitalization. Most importantly, we continue to rely on the mechanism for further assistance in national prosecutions. The Court of Bosnia and Herzegovina, both in the previous and current year, has had successful communication with the mechanism regarding the resolution of various procedural dilemmas. Further to that, regular operational discussion and consultation between OTP and the Prosecutor's Office of Bosnia and Herzegovina, as well as OTP's continuous case assistance to the Prosecutor's Office of Bosnia and Herzegovina, remains essential in securing justice for all victims of crimes committed in Bosnia and Herzegovina. Later, in particular, important, having in mind that requests for assistance from Bosnia and Herzegovina accounts for about 80% of regional requests. With a backlog of cases concerning suspects known to reside outside Bosnia and Herzegovina, and with aim of removing the procedural obstacles so they could ultimately be prosecuted, the High Judicial and Prosecutor Council of Bosnia and Herzegovina adopted a conclusion recently in February 2025 in which it finds justified the initiative of the Court of Bosnia and Herzegovina to transfer war crimes cases against inaccessible persons to states in the region or to the states in which these persons are located in the event of the absence of the possibility of their extradition, regardless of their legal qualification of the criminal offense, as the only possible way of initiating criminal proceedings against these persons and concluding them with a court decision. We are yet to see these arrangements come to fruition since the track record of war crimes prosecutions in some countries of the region is far from stellar. To the effect, we commend the UNDP regional project, EU support to confidence building in Western Balkan, that is currently working on implementing activities aimed at strengthening regional cooperation in the prosecution of war crimes cases between judicial institutions of Western Balkan countries, Bosnia and Herzegovina, Serbia, Montenegro, and North Macedonia, namely, in order to contribute to the social cohesion, reconciliation, and long-term peace and stability in Western Balkan countries. Madam President, but much more is needed that the empty assurances of one's commitment to accepting and processing such a case is to achieve justice and strengthen the regional cooperation and reconciliation. Simply for the fact that unavailable suspects remain unavailable for the reason. They are shielded, protected, celebrated, rewarded, and honored for the crimes they have committed in Bosnia and Herzegovina. Crimes are still denied. Victims and their families have been humiliated day in the day out of past 30 years. Further to that, the denial of crimes, revisionism, and glorification of war criminals continue unabated and even worsen over the time. Anniversaries, Madam President, a lot of you mentioned that, come and go. Some serves for reflection on positive thinking, things achieved, challenges we faced, and progress we have made. Some more somber are there to remember, commemorate, and honor, with dignity, with respect, with honesty. So 30 years after horrific crimes committed in my country in the name of vile ideology, will that be the case? Today's session comes right in between two painful anniversaries in Bosnia and Herzegovina. The 30th anniversary of the horrific crime in Tuzla committed on May 25, 1995, and 30th anniversary of Srebrenica genocide committed in July 1995. May 25 was once celebrated as a youth day in our country. Ironically, on that very day in 1995, a grenade was fired from aggressor's position in Mount Ozren, killing 71 people, young people, and wounded more than 200 at the youth gathering in Tuzla. Novak Đukić, we just heard his name in one of the interventions, an officer in the Republika Srpska army, was found guilty of ordering artillery platoon, a commander of Ozren Tactical Group, to shell Tuzla with cannons on May 25, 1995, and was sentenced for 20 years in prison. After escaping from Bosnia and Herzegovina, where? To Serbia. He became inaccessible to our country's judicial institution. He had found refugee in Belgrade, but neighboring Serbia refused to extradite him. And to this day, there is no reckoning with the Srebrenica genocide. Denial is avoided, convicted murderers celebrated, judicially established facts and history distorted and violated, victims dehumanized. Coming to terms with the past and accepting the truth is far from reality, both in parts of my country as well as in neighboring Serbia. Time and again, opportunities to come to terms with the past and offer an honest hand of reconciliation are being missed. The adoption of the resolution aiming to honor victims of crimes adjudicated before the ICTY and ICJ, should have been one such opportunity for common action, not a shameful nationalistic narrative and revisionist of history. Instead of working so hard to make martyrs out of these cowardly killers, or unarmed men, women, and children, rapists, and altogether human scum, they should invest in the future of their country and our region by finally shaking off the burden and legacy of the past regimes and embrace justice, truth, and true reckoning. instead of vocal appeals and pledging on behalf of convicted criminals, such as Mladic and Karadzic, on humanitarian or any other ground, they should show humanity and consciousness to those more deserving, to victims and survivors of those murderous monsters. The upcoming 30th anniversary is certainly an opportunity to do so. At least today in Security Council, less than a month before official 30th commemoration and reflection of Srebrenica genocide, year after the United Nations General Assembly established International Day of Remembrance of Srebrenica genocide, I expected to hear words of respect for victims and survivors of genocide in Srebrenica, not being genocide denier and prosecutors of war criminals sentenced for high scale of crime, act of genocide, to be released. Let me remind you, 12 years ago, it was 12 years ago, well-known sentenced war criminal, Vojislav Šešelj, was released earlier from prison, serving a sentence for war crimes as an act of mercy because, as he claimed, be backed by Serbia, that he's terminally ill. That was 12 years ago. Now, for more than 12 years, he keeps promoting what he did and denying work of court and ultimately the verdicts for genocide. 6 years ago, I think it's about 6 years ago, General Mladic stated in continuum asking to be released because of terminal illness, regardless of life sentence, that he was convicted for genocide. Of course, we cannot offer a right to life to their victims being terminally dead, but we can work on keeping justice alive as well as memory of victims as preconditions for reconciliation and prevention of such crimes against to anyone, to anywhere, and any time in the future. Madam President, the Holocaust round Srebrenica, we truly regret that neither of those lessons did much to prevent the repetition of the pain, suffering, and death, to prevent an unimaginable level of cruelty one human being can inflict on another. We truly regret that killing continues today in front of our eyes in different parts of the world. In our case, at least, it is not by arms but by words. With their denial, utter attack of remorse, and willingness to face the truth, vitriolic outbursts that promote future violence, they also kill an opportunity to finally put to rest painful and horrific past for the sake of healthy relationships, trust, and cooperation for the future. In spite of, or despite of all it, we still firmly believe in strength and power of truth, confirmed and preserved in judicial proceedings, in the power of accountability, but mostly in delivering justice for crimes committed. Without the trials and judgments, without the survivors telling their harrowing stories, crimes would fade into oblivion, minimized, erased, and punished. But in our firm stand and insistence on justice, that is no longer possible. It is essential to accountability, to warning, and to prevention. The Council was innovative and courageous in taking unprecedented steps that forever transformed the landscape of international justice and enabled the advancement of international law through a substantial body of jurisprudence on genocide, crimes against humanity, and war crimes. There is no turning back on that decisive moment for justice. If anything, then for the very fact that it moment at the core of almost all the issues of the Council docket massive violations against human life. Women, children, and innocent people turned their eyes to this chamber on hope of protection, salvation, and hope of justice. We heard in here some names improperly mentioned. We heard in here out of blue, out of nothing, out of the sky, naming the President Ali Izetbegovic, the President of Bosnia and Herzegovina, the first President of Bosnia and Herzegovina, who was never committed by any international court, and putting him in a context of Karadzic, Mladic, and others. It is absolutely unacceptable. But on a second thought, when I heard that second time today from the person who was naming President Izetbegovic, when I heard him repeating something which I thought is improper cynicism for even, especially for this setting, to put in the same context Mandela and Mladic, there is no wonder that we hear such a brutal offenses like naming President Izetbegovic on the same term like General Mladic and Karadzic's in context in this thing of agenda. Of course, we learned a lesson from that, and for the record, Minister's name is not Vucic, as you keep insisting calling him. His name is Vujic. I know that so I just want to correct that Minister is Vujic, regardless of the fact that I thought that I heard Vucic as well. Thank you.
I thank the representative of Bosnia and Herzegovina for his statement, and apologies to the minister for mispronouncing his name. I'll make sure I get it correct if there is another opportunity. I now give the floor to the representative of